On behalf of the NBSAP Forum, good morning, good afternoon to all of you. It's a pleasure to have you all here with us today. I want to welcome you all to a webinar series on human rights, environment, and biodiversity. I'm Eva Gurria with the NBSAP Forum and the United Nations Development Program team. Again, thank you for attending today's session on Introduction to Human Rights and the Environment. Today, I will help facilitate this session together with my colleague, Victoria Beresheniuk from the NBSAP Forum team, who will provide technical support. In today's webinar, we will have an overview of historic developments in human rights and environment, including a synopsis by our presenters of the UN Special Rapporteur on Human Rights and the Environment, John Knox's report on the right to a safe environment, including biodiversity. Today's presenters will also discuss key sectoral elements such as human rights and ecosystem services, and elaborate on the obligations of the state and stakeholders for a safe and healthy environment and biodiversity, as well as to a just, peaceful, and inclusive society. Now, for today's webinar, we have a fantastic group of speakers, and I'd like to introduce the first speaker and the moderator of today's webinar, Dr. Balakrishna Pusapati. Dr. Balakrishna Pusapati is an internationally renowned conservation and development specialist with close to 3 decades of experience working at national, regional, and international levels. He was Vice Chancellor of the Transdisciplinary University in India, Chief of Biodiversity at UN Environment, Senior Policy Fellow of Frishof Nansen Institute, Chairman of the National Biodiversity Authority in India, Coordinator of the Biodiplomacy Program at the United Nations University, Head of the Regional Biodiversity Program for Asia at IUCN, and the Head of Biodiversity and Biotechnology Program at the M.A. Swaminathan Research Foundation. He has also advised multiple countries on conservation and development policy and served as advisor to international bodies such as the China Council for International Cooperation on Environment and Development, the Global Environment Facility, the World Bank, and the United Nations Development Program, among others. So we're extremely honored and happy to have Dr. Pusapati here with us today. Dr. Pusapati is currently the chairperson of the Forum for Law, Environment, Development, and Governance, known as FLEDGE, based in India. Now, before I hand over the microphone to Dr. Pusapati, I'd like to address some of the logistics of today's webinar. We have up to 2 hours for this webinar, and after the presentations, we will proceed with a question and answer session that I will facilitate. To make your questions, please write them on the chat box in the control panel in your screens. You can also ask the question by clicking on the hand icon in the control panel on your screen, and we will then proceed to open your mic so you can ask the questions to the presenters. I encourage you to think of your questions as you hear the presentations. And unless we open your mics, all attendees, except for speakers, will be in listening mode only. This reduces interference and facilitates communication. However, you can continue to think of your questions and write them on the chat box even before the question and answer session. Also, as many of our participants are not native English speakers, myself included, I would like to remind speakers of the importance of speaking slowly and clearly. Lastly, the session is recorded and it will be available at the NBSAP Forum website. That is nbsapforum.net. And all of the participants will receive an email with a link to watch the presentations as well as a PDF copy of the presentations. So without further ado, Bala, you have the microphone, and everyone enjoy the session.
Thank you very much, Eva. Very good morning, good afternoon, good evening, colleagues who actually have joined us for this webinar session and who will continue to join us as we move through. And I'm more grateful for you having spared this particular day of Monday, Thursday to join us, showing your interest and commitment to this particular subject. We have 4 speakers, including myself, who will be speaking, introducing the topic of human rights, environment, and biodiversity. And as he was mentioning, we are very grateful to the NBSAP Forum. Many of you are probably familiar with the forum, which is a joint effort of the United Nations Development Program, the United Nations Environment, and the Secretariat for Convention on Biological Diversity. And this particular webinar series is also co-sponsored or hosted by SwedBio at the Stockholm Resilience Centre and the Forum for Law, Environment, Development and Governance based in India. We're still waiting for one presenter to join from Nairobi. What I thought I'll do, just to ensure that we have clear flow of the different presentations, I'll first introduce the speakers to you so that we can quickly move into the presentations. We have Dr. Arnold Kyle-Huber, who will be joining us from Nairobi, who is the Deputy Director of the Law Division of UN Environment. Previously, he was the head of the International Law Unit, and most of his work focused on issues of environmental law, primarily on issues of environmental crime, human rights. More recently, he worked on UN environment response to attack on UN defenders. In 2012, he led planning and organization of the World Congress on Justice, Governance and Law for Sustainability as a part of the Rio +20 process. And he's also the UN Environment Focal Point for coordination on issues of rule of law, as well as a Global Forum for Law, Justice and Development. He's a legal counsel at UN Environment and National of Austria, as a doctorate in international environment law from University of Vienna. We have another speaker, presenter, Ms. Alfonso Jojan, who is an environmental lawyer, currently working as a senior research assistant with Dakshin Foundation, and also is an honorable fellow at the Forum for Law, Environment, Development and Governance. She had earlier worked at the Transdisciplinary University, the National Biodiversity Authority, Government of India, Natural Justice, and she holds an LLM in law from Azim Premji University in India. Our last presenter for today is Dr. Claudia Ituarte Lima, who is actually an international law researcher and advisor at SwedBio at the Stockholm Resilience Centre. She focuses on transformation of international law, in particular biodiversity, climate change, and human rights law, into governance forum at national and local levels. She's a member of the expert group on policy tools and methodologies of the International Platform on Biodiversity and Ecosystem Services, IPBES, and advised the Convention on Biological Diversity. She also provided expert advice to the UN Special Rapporteur while preparing the Human Rights and the Environment Report, and also advised the International Development Law Organization. So these are the 4 presenters or the speakers we have. And with your permission, I'd like to start my first presentation, which is to give you a bit of an overview and introduction to the sessions. And one another point I'd like to mention before I start is that we actually have split the entire series into 3 different sessions. The first session that we are on today will provide you a bit of an overview in terms of human rights, environment, and biodiversity, including linkages to the Sustainable Development Goals. We have the second webinar that will happen next Thursday, which is on the 5th of April, where the focus of the webinar would be on human rights, business, and biodiversity. And the last in the series of 3 webinars will be held on the 19th of April, where the focus would be on looking at human rights, biodiversity, contributions of the indigenous and local communities, and more directly inputting into the Convention on Biological Diversity processes including the upcoming discussions in shaping the post-2020 global biodiversity strategy and the related targets. So that's the kind of a planning. And for those of you who have registered for this webinar, you automatically are registered for the other 3 webinars also. You don't have to re-register. So with that, let me quickly move into my presentation. And I'll wait for Alnal to come online. He's having some technical problems in Nairobi. So once he comes online, I'll give the floor once my presentation is over, if he's ready, to give the perspectives from UN Environment Program. As you know, UN Environment had led a lot of global efforts in shaping up the entire agenda on human rights, environment, and biodiversity for many, many years. And I've worked closely with the UN Special Rapporteur on Human Rights and Environment in preparing the report that we are all familiar of. So my presentation would be, as I mentioned, an overview presentation. And as I mentioned, that the webinar series would cover the following components: an overview on human rights, its links to environment and biodiversity, reflections on the report of the Special Rapporteur on Human Rights and Environment. Many of you are familiar with it. And as a part of preparations for this webinar, Eva and the NBSAP Forum has also put together a set of reading lists. For those of you who are interested to pursue and read a little more deeply into some of these topics, you can certainly consult some of the reading material, including the report that is available online. The seminar series would also look at linkages with issues of rights-based approaches to conservation and sustainable development. It will discuss the business perspectives on human rights, ongoing discussions to link with issues under the Convention on Biological Diversity. It also will provide inputs into the discussions on the post-2020 global biodiversity strategy and inputs into the SDG-led discussions on rights-based approaches for development. So that's basically the overview of the webinar series in total. Let me very quickly give you a bit of an historical perspective. Many of you who are environmental lawyers would already recognize that environmental rights are enshrined in more than 100 constitutions across the world, which is a significant, both not only in terms of the numbers, but also in terms of the attention environmental dimensions have received in terms of a constitutional right. And courts at least 44 nations have issued decisions enforcing constitutional right to healthy environment. And increasingly, we are seeing more and more case law and jurisprudence that is being built around the issue of human rights, environment, and biodiversity. And of course, we are all grateful to the Principle 1 of the Stockholm Declaration on Human Environment, which actually laid to an extent the basics and the foundations for some of the work that we are discussing here today, when the Stockholm Declaration proclaimed that man has a fundamental right to freedom, equality, and adequate conditions of life in an environment of quality that permits a life of dignity and well-being. So that, to a large extent, lays the foundation for a lot of our work on human rights and environment. In spite of larger amount of attention on the issue of human rights and environment, it is also a little disheartening to note that around 40 to 50% of the 197 environmental defenders who got killed in 2017 alone came from indigenous and local communities. So certainly, on one hand, we are discussing human rights, environment, but on the other hand, we are also fighting for the rights of the defenders who are increasingly being targeted and who are increasingly being killed. And in this regard, it is very heartening to note the initiative of UN Environment, who actually had launched a very special program supporting the environmental defenders a few weeks ago. And of course, when you're looking at the environmental rights, the violations had had a profound impact on a wide variety of human rights, including right to life, right for self-determination, right for food, water, health, sanitation, housing, cultural, civil, and political rights. So certainly the need for us to focus on human rights using an environmental lens, and more importantly, the biodiversity lens, is particularly important because of this growing influence and impact of both the positives of countries and constitutions and jurisprudence increasingly focusing on environmental issues and human rights, but on the other hand, a large amount of challenges in terms of how people on the ground are perceiving some of these rights as well. And of course, when you're looking at the rights dimension, we have both the procedural rights and substantive rights. And my colleague Alfonso Jojan will be speaking about the possibility of focusing about the details of both the procedural rights and the substantive rights as we move ahead. If you look at the international dimension of human rights, environment, and biodiversity, it all started with the UN Charter 1945. And what I've done, because of the participants' our intent and interest to focus on the issue of environment, more particularly from the biodiversity angle, would like to sort of throw in the number of international multilateral environmental agreements and conventions that all actually are contributing as well as getting impacted by the issues related to human rights, whether it is the Ramsar Convention of 1971 on wetlands and waterfowl habitats, the Convention for the Protection of Natural, Cultural and Natural Heritage Sites, the Convention on International Trade in Endangered Species of Wild Flora and Fauna, CITES of 1973, the United Nations Convention on the Law of the Sea, and of course the 3 Rio Conventions, the UN Framework Convention on Climate Change, the Convention on Biological Diversity, and 2 protocols of the diversity, both the Nagoya Protocol on Access to Genetic Resources and Fair and Equitable Sharing of Benefits, which is actually a protocol to the Convention on Biological Diversity, and the United Nations Convention to Combat Desertification. So essentially, when we are looking at the elements of human rights, environment, and biodiversity links, they are already a part of a large number of these agreements, treaties, and discussions that are happening. But what is actually happening differently now is that there is actually a very special focus on bringing out the human rights perspectives and dimensions of each of these frameworks to actually come together to form a much larger base for us to start focusing on implementation, compliance, and realizing the objectives of each of these international legally binding components of it, as well as a set of non-legally binding instruments, such as the Declaration of the United Nations Conference on Human Environment, the 1972 from Stockholm, the Rio Declaration on Environment and Development from Rio in 92, Agenda 21 of 92, and also the lastly, the outcomes of the Rio +20 document, the future we want. So essentially, we are actually redefining the way we are looking at environment and biodiversity and human rights, but our understanding to deal with it in terms of compliance, in terms of implementation, is also something which is enormously increasing, thanks to academic research, thanks to work of UN agencies and civil society, thanks to work of the executive, as well as thanks to the work of the judiciary. So essentially, everyone is coming together to provide us a much stronger and a larger platform to discuss this. But if you're looking at the approaches that are already in place, or the kind of approaches that are emerging in terms of dealing with issues of human rights, environment, and biodiversity, I'm actually putting them or categorizing them into 3 different components. The first approach that looks at environmental protection as a precondition to the enjoyment of internationally guaranteed human rights, especially the rights to life and health. That has been the first approach which we've followed. Subsequently, we had another approach that looked at environmental protection as an essential element of human rights. And the third approach, which we are now currently pursuing, is to look at it as a right to a safe and healthy environment as an independent, substantive human right. So essentially, the kind of evolution, both in terms of the thinking, the approach, the discussions, the negotiations, and decision-making that has happened in terms of human rights, environment, and biodiversity had evolved over a period of time, where today we are looking at healthy environment as an independent, substantive human right. And that's where the entire discussions of this webinar series takes much larger prominence, where we do recognize and we do understand a large amount of assessments, including the assessments that were launched at the International Platform on Biodiversity and Ecosystem Services, the regional assessments that were launched a few days ago, and the Millennium Ecosystem Assessment, which was launched about 12, 13 years ago. All of them recognize that the human ability to enjoy life depends on healthy ecosystem. And a healthy and a resilient ecosystem has to have a set of biodiversity that actually is healthy, that is diverse, and that is active and functioning. So essentially, biodiversity is essential for human rights to enjoy their rights. So that's the kind of a linkage we are looking at. But if you're looking at very specific specifically the element of human rights and biodiversity, we can categorize them. This is actually not an exhaustive list, but it's just an indicative list of areas that needs more attention as we move forward. In terms of food security and nutritional security, in terms of health security, access to ecosystem goods and services, traditional knowledge and rights of indigenous people and local communities, and economic development. And what I thought I'll do is very quickly provide you a bit of a broader framework on where the rights-based approaches would come in to deal with each of these areas of focus. Right to food, access rights, rights for land tenure, government support prices and markets, fundamental for food and nutritional security. But of course, all of these need to be combined with the right to grow specific varieties, support for processing and storage, access to primary health care and related linkages. And this also links to the rights for access and sharing of germplasm for emerging needs. So we are looking at a bunch of different entities and elements that combine together to promote the linkages between human rights and biodiversity in this perspective. If you're looking at human health, we are looking at rights-based approach to access to medicines. We're not just only looking at tertiary healthcare, we're also looking at home healthcare, the primary healthcare, the secondary healthcare, and tertiary healthcare. The traditional healers and practitioners today, even though they are actually contributing a lot to primary healthcare practices at the household level, at the local level, a lot of their practices, a lot of their contributions to health is something which is really not being recognized appropriately. And in many countries, including India, traditional healers often are facing a lot of problems in terms of even having their practices in place. And because of the nature of their work, we also need to look at right to land and tenure, access to markets, and most importantly, the ability of people, both urban and rural, to spread the health risk and the economic risks associated with human health. If you're looking at access to ecosystem goods and services, we are looking at forest dweller rights, access to resources, both in terms of harvesting the resource and using the resource, access to land and tenure, right of use, payment for ecosystem services, and to combine a large number of these in their ability to reconcile actions for their own sustainability. Looking at traditional knowledge and indigenous people and local communities, most of the approaches, most of the elements like the biocultural protocols, Article 12 of the Nagoya Protocol very clearly recognizes the contributions of the biocultural protocols for implementing the access and benefit sharing provisions. But we need to reiterate that the traditional knowledge, indigenous local communities use the rights-based approaches much better. The rights of benefits from ABS is passed on to communities who should be benefited by such actions. The principle of free and prior informed consent on action is something which needs to be reiterated. The first right of refusal for development, access to resources, land, markets, and support. Combining all of it, rights to safeguard traditional practices based on tenurial rights. That includes those related to protected areas and areas for development. And at this point, I'd like to draw your attention to an associated report of another special rapporteur who was commissioned to actually develop a report on human rights and indigenous and local communities, where the special rapporteurs have very clearly outlined the links between the way we are currently managing protected areas and the areas for development and human rights and indigenous local communities. So certainly it's worth a read for those of you who are interested to pursue this particular topic. And in terms of the economic development, looks at rights to development choices, rights to spread risks and promote resilience, rights to reduce vulnerabilities, and lastly and importantly, rights to make choices and decisions. So these actually are the dimensions and the elements that we are looking at currently through this particular webinar series. We have about 7 or 8 speakers who will be joining us through a series of these 3 webinars, who will be elaborating elements of each of it in much more depth based on their expertise and based on their own research that actually had led us to providing a lot of inputs into the Special Rapporteur's report on human rights, environment, and biodiversity. And for those of you who are interested, a lot of ground has been covered in this particular regard, whether it is through the UN environment process of the UN General Environment Assembly, as well as the convention process through the Conference of Parties, where there was a side event that was held in Mexico during COP13 on human rights and biodiversity, and one at the last meeting of the UN Environment Assembly on human rights and environment. So essentially, the sound bites are already out there. What we now need is, how do we actually knit, how do we connect the different dots in terms of connecting the social, economic, and the environmental dimensions into a human rights and a human rights-based approach to both conservation as well as development. So at this point, I'd like to pass on to my colleague Alfonso, who basically will be making the next presentation.
Bala, if I may interrupt, Arnold has actually joined today's webinar. So if you would like to give the mic to Arnold.
Sure, perfect. Arnold, welcome. I've just sort of introduced you as the Deputy Director of UN Environment Law Division at UN Environment in Nairobi. And the floor is yours, Arnold.
Thank you very much, Bala, and apologies again. We had some technical issues, but we have heard you and your presentation. At least we had the audio. And I would suggest, in the interest of the webinar, and given the fact that we're connecting late, I don't want to take us, backwards in terms of the program, as you have already very eloquently outlined, Bala, how far we have come as far as human rights in the environment is concerned, and what the current challenges are. You also have done a lot of the UN environment advertising, if you will, for us, because obviously you have intimate knowledge. I just wanted to say that we're very proud to be associated with this effort. It is a very timely effort. If you just look at biodiversity, perhaps as the next frontier when it comes to environmental rights, when it comes to making the linkages between human rights and the environment, just like John Knox has done with his latest report to the Human Rights Council. But we also feel perhaps in the field of environmental litigation. Climate change litigation has been talked about a lot. We feel in UN Environment probably the next wave of environmental litigation that will keep governments, policymakers, lawmakers, but also the courts around the world busy could be related to biodiversity, simply because, as you have said, Bala, already, the importance of biodiversity and biodiversity conservation for human rights and vice versa. Bala, this webinar is largely, your effort, and on behalf of UN Environment, I want to thank you and your team for putting all of this together. We're very happy to be associated along with the other collaborators, with your trust, FLEDGE, and UNDP, UN Global Compact, Natural Justice, and all the other partners that have helped make this webinar happen. As you have said, we have worked a lot with the Special Rapporteur. We have put reports out that have made these linkages over time, and you have already said that we moved, from early approaches now to advocating for the right to a clean and healthy environment as a human right. And that for us is already a big success. And now we need to see how we can instrumentalize that and see how we can stimulate the UN and UN agencies to catch up in many ways with the developments at the national level, because in many ways countries are already way ahead of the UN system when it comes to this question. I would like to invite all of you to join the Environmental Rights Initiative that Bala has also already mentioned, which really aims to create a broad coalition of partners that want to advocate around environmental rights around the world. This will include greater protection for environmental defenders, shining a light on what they're doing, but it will also include targeted capacity building activities. For example, for the judiciary, we have a very successful program which is almost complete, where we sensitize judges around the world on constitutional environmental rights. And so we want to do targeted capacity building going forward. This will not just be a campaign, an advocacy campaign, but also targeted capacity building activities for all stakeholders involved. Together with SPED Bio and other partners that are also associated with this webinar, In May of this year, we also plan a dialogue, and we want to then link this work also a bit closer with SDG 16, which is the rule of law SDG. And we are also very much convicted that if we don't, that if we don't increase rule of law in the field of the environment, what governments have termed in the governing body of UN environmental rule of law, then we will also not make much progress in terms of implementing the linkages between human rights and environment on the ground. And we want to then hopefully also through this webinar make linkages to intergovernmental processes. I've said the UN system needs to catch up in many ways to national developments. So the next UN Environment Assembly, but also discussions within the Convention on Biological Diversity, the subsidiary body on implementation, for example. We hope that we can relay the outcomes of this webinar, this series of webinars, and some future activities to these intergovernmental processes, because we feel if we do these things together and try and influence the system and the whole world, if you will, together, then we will have a better chance at success. Bala, I will leave it at that. Apologies again that we connected late. This is great stuff that we talk about human rights and biodiversity in this manner. And back over to you.
Thank you, Arnold. Thank you very much for that perspective, and welcome. I hope you can stay online for a little more time just to listen to the other presenters as well. Over to Victoria.
We will be online throughout.
Sure. Thanks a lot. Victoria, over to you.
Thank you, Bala. This is Eva. We're now opening Alfonsa's screen.
Hey,
And we can hear.
I'm Alfonsa. So I'll be speaking about human rights and biodiversity and the linkages between them. I will be discussing.
For 2 seconds. Would you mind making your?
Can you hear me?
Yes. Could you make your full screen, please?
Can you hear me?
We can hear you. Would you just?
Can you also see my screen?
We can see your screen. Can you just make it a full screen? So at the bottom, just make it there.
Yeah. All right. Yes.
Thank you.
So I'll be discussing the linkages between human rights and biodiversity, and I will be discussing the jurisprudence of the international dispute resolution bodies, especially the human rights bodies, in discussing what are the linkages with respect to biodiversity that they have ruled on. And I will be also discussing the principles and approaches under the biodiversity related conventions with respect to human rights. So I'll start with the thematic report of the Special Rapporteur, Professor John Knox, presented to the Human Rights Council in January 2017, which lays down the procedural obligations, substantive obligations, and special obligations with respect to conservation and sustainable use of biodiversity.
Sorry,
this is a thematic.
This is Eva again. Just if you can click on the one right next to it, which will make it a full screen. It's currently on the third one. If you put it on the fourth one, down there at the bottom, all the way to the right.
Yeah. All right.
That one.
Yeah. Okay. Thank you. Sorry about this. But yeah. So just to kind of discuss what are the procedural obligations that the Special Rapporteur has discussed in this thematic report on biodiversity. There are 3 kinds of obligations that he has mentioned. It includes assessing the impacts of any development projects on biodiversity and making this biodiversity information public. The second one includes facilitating public participation in environmental and biodiversity decision making. The third one is to provide access to remedies for any harm that is being caused to the biodiversity due to development activities or other kinds of activities. These are the three obligations, procedural obligations that he has discussed. Moving on to what are the substantive obligations mentioned in the report, it includes the obligation to adopt legal and institutional mechanisms for protection of biodiversity and ecosystems. He also discusses about the special obligation of the states of the country to protect vulnerable people and people who depend on ecosystem and biodiversity, including the indigenous peoples and local communities, women, children, and elderly and disabled. So this report, it was submitted to the Human Rights Council, and the Human Rights Council endorsed the report in March 2017. They also resolved and called upon the member states to facilitate public awareness and participation in environmental decision making, to promote safe and enabling environment for environmental defenders, to provide effective remedies for human rights violation, and also to establish legal and institutional frameworks for protecting biodiversity and preventing, reducing, and remedying harm, which basically covers all the procedural obligations and the substantive obligations that the Special Rapporteur has talked about, and also the special obligations with respect to vulnerable sessions, including indigenous peoples and local communities. When you also kind of look at whether these obligations are new obligations under the international law, we can see that these are not really new obligations, but come from the jurisprudence of different dispute resolution bodies, and it also comes from different international treaties such as the Biodiversity Convention on Biodiversity, the CITES, the Ramsar, etc., which I will be discussing next. So when you look at the jurisprudence of international courts, the ICJ, the International Court of Justice, in Pulp Mills case, has extensively discussed the procedural obligations and substantive obligations towards conserving biodiversity and ecosystems. This case was regarding the equitable and sustainable utilization of a transboundary river, the River Uruguay, which borders the country Argentina and Uruguay, and there was the Uruguay was building a couple of pulp mills in its side, and Argentina made a case to ICJ, the International Court of Justice, saying that Uruguay has violated a lot of procedural obligation, a lot of substantive obligations towards conserving biodiversity, and also a particular treaty, that a bilateral treaty that these two countries have adopted. So in this case, the ICJ ruled that the most important fact about this case is that environment impact assessment, which is, as we saw in the first slides, is one of the integral component of your procedural right, is declared to be a general principle of international law. The case also discussed that the parties has to take due diligence with respect to conserving and using any bioresources or ecosystem, and which the due diligence includes right of the affected population to be consulted before an activity is taken, right to the obligation of the parties to undertake environmental impact assessment and like. Another important aspect about the case is also that the court discussed that the international undertakings of the states under CBD, CITES, and Ramsar are very important and forms an obligation of the states with respect to conserving ecosystems. When we move on to the other regional human rights courts, which is the Indian American Court and the African Human Rights Court and Commission. They have also ruled on the importance of right to environment and its effect on human rights. It is pertinent to also note that we don't really have an international right to environment, but we do have obligation with respect to environmental protection, which we have seen the procedural obligation, substantive obligation, and special obligation. But in regional courts, they have the regional parties, countries, and states have adopted a specific right, human right to environment. And if you look at, this was emphasized in a very recent case, which is an advisory opinion requested by Colombia in 2017. The Inter-American Court declared that there is a human rights to environment. It upheld that particular human right, and also it extended the obligation of a country to protect the rights of this particular environment to those not really living in the territory of a particular state, but also to those living outside. Another important case which discussed the obligation of multilateral cooperation and obligation of the countries to hold multilateral cooperation in holding them responsible for not violating the right to environment is discussed in Sarayaku versus Ecuador. So when we come to Africa, African Commission and African Court of Human Rights have discussed extensively the importance of biodiversity and ecosystem with respect to human rights. And one of the major cases is the Ogoni land case, which is basically the case discussed and about the degradation of territory of Ogoni peoples caused due to oil production and exploration and exploitation by a multinational company in Niger and Niger Delta region. So this case discussed that the state of Nigeria has violated the rights of Ogoni people. These rights include the right to safe environment, right against non-discrimination, right to life, right to food, right of people to freely dispose of their wealth and natural resources. And the interesting fact about this case is that it held and it also elaborated the linkages between biodiversity and ecosystem and their role in providing food resources for indigenous peoples in local communities. And with respect to that, the court very specifically held that right to food of Ogoni peoples is violated because of the degradation of their territory, including ecosystems and biodiversity. The next case is another important aspect of human rights and the linkages between human rights and biodiversity, because this case does not talk about the activity, a development activity of a private party, but it talks about the conservation activity of the state. This is the Oggie case, which is also a recent one. In this case, the African court held that the eviction of Oggie people from Mao forest, which is their traditional forest, their territory, is a violation. It's a violation of right to property. It is a violation against non-discrimination. It's a violation of their right to culture. It's a violation of their right to development. So this is very pertinent because we have a lot of discussions on what are the human rights standards for conservation, and this case discusses about how, if you want to carry out conservation activities, what are the human rights that needs to be respected and what should not be violated. So these are the linkages and of biodiversity within the human rights system. Now I will talk about what are the human rights principles and human rights linkages within the biodiversity conventions. When you talk about it, there are a lot of variety of general international law principles we can kind of think and lay down these linkages, which includes common but differentiated responsibility, access to information, participation in decision making, and access to redressal and remedy, precautionary principle, polluter pays principle, environmental impact assessment, etc. But I will be focusing on two aspects of this. One is the concept of benefit sharing. The other one is the concept of recognition of rights, a variety of rights of indigenous peoples and local communities within the biodiversity related conventions. So the concept of benefit sharing is founded upon the the human rights principle of equity, and the biodiversity related conventions offers a unique opportunity to integrate human rights principles through this concept of benefit sharing within itself. So the source of this benefit sharing concept can be found in Universal Declaration of Human Rights, can be found in Ramsar Convention, the CBD and its protocol, and also the ITPGR, International Treaty for Plant Genetic Resources. If you kind of examine the element 2 of the program of work on protected areas under CBD, which talks about benefit sharing while undertaking conservation activities, this is the concept of benefit sharing is reflected in the element 2 of protected program of work on protected areas. The other aspect is other legally binding instrument is the Nagoya Protocol, which is basically discussing and elaborating the third objective of Convention on Biodiversity, which is access and benefit sharing, where the concept of benefit sharing is essentially included. It talks about what are the obligations of the states and with respect to benefit sharing when any country is accessing genetic resources and using genetic resources for certain certain purposes. It also talks about the obligations of the user countries with respect to the indigenous peoples and local communities and their traditional knowledge and the innovations around it. So you can see the ITPGR also talks about benefit sharing and elaborates a mechanism of benefit sharing. So these concepts and this concept of benefit sharing embedded in biodiversity related convention offers a unique opportunity to integrate human rights principles within the biodiversity system. Likewise, various rights of indigenous peoples and local communities are acknowledged and recognized in biodiversity related convention. For example, Article 8J and Article 10C of CBD, Article 12 of Nagoya Protocol, as explained by Dr. Bala, kind of talk about what are the rights of indigenous people, and it includes the right to manage their own resources. It includes the right to hold and control their traditional knowledge and innovation. Next, I'll kind of talk about what is a way forward for the international bodies, especially the bodies associated with the biodiversity conventions, to integrate the human rights framework principles within it. I propose that ecosystem approach is one of the way that they can integrate the human rights framework and also the development in the human rights system, because the ecosystem approach recognizes human beings and their cultural diversity, and also the 12 principles of ecosystem approach as the guidelines are built on various human rights related obligations. So if you see the procedural obligations of human obligations towards conservation and sustainable use, the principle 1, 2, 3, 4, and 11, 12 speaks and correspond to these procedural obligations. Principle 2 encourages decentralized management, which encompasses the essence of procedural rights. Principle 3 talks about impact assessment. Principle 4 talks about internalizing costs, which is one of the ways of providing compensation. And when you talk about the substantive obligation, the ecosystem approach is the framework for action of most of the biodiversity related conventions. And the the concept of ecosystems are also built on the notion that they're open and interconnected, which is very similar to the human rights characteristics of human rights, which is interdependency and indivisibility. And ecosystem approach also recognizes the indigenous people and local communities as an important stakeholder in biodiversity related matters and governance, and also they recognizes indigenous and local knowledge and innovations and practices. With this, I end my presentation, and one of the aspects that I would like highlight is there is a need to reinvigorate, to review the ecosystem approach with the current developments in the human rights systems. Thank you.
Thank you so much, Alfonso, for your presentation. We will now proceed to Claudia's presentation.
Hello, everybody. It's a pleasure to be here with you. So my presentation will focus on how do we weave the human rights principle and Sustainable Development Goal 16 on peace, justice, and strong institutions with the Convention on Biological Diversity. We all know this SDG 16 is an integral part of the Agenda 2030. So I have been working for more than 15 years on linking human rights, biodiversity, ecosystems. And in the beginning, it was difficult for both in academia and more policy and practice, governments, NGOs, to argue that they were intrinsically connected. And now we really see a momentum to address these topics. And it is really exciting, as other of my colleagues have highlighted already. So biodiversity, healthy ecosystems, and human rights law. As a way of an illustration, I would like to recall the work of Wangari Maathai, who was one of the founders of the Greenbelt movement, who's now celebrating its 40th anniversary. She was a visionary in terms of connecting sustainability, human rights, and peace. And she viewed this nature's contribution to people, although she perhaps didn't use that name, but she saw how deforestation was heading towards degradation of the environment, and that affected the well-being of many, many people, starting with her native Kenya. She started working hand by hand with rural women in Kenya and was really clear of how exercising people's right to association, participation, was intrinsically linked with other substantive rights. By planting native trees, these services that nature provides, specifically soil formation, supporting services, we're also contributing to others, such as regulating, for example, water purification, climate regulation. She also encouraged people to reconnect with the traditional crops, nutritious crops. And by doing so, services such as provisioning services, food, fresh water, wood, and fiber could also benefit people. And here we see that by doing that, a whole range of different rights could be supported: right to health, right to food, right to adequate housing, right to water. And this can also help us think here. This is based upon the Millennium Ecosystem Assessment and the Intergovernmental Platform for Biodiversity and Ecosystem Services. And we see their conceptual framework. If you see to the right-hand side, anthropogenic drivers, such as mining or deforestation, which I mentioned earlier, affecting nature. And what this conceptual framework does is, if you see in the green parts, biodiversity and ecosystems, ecosystem goods and services, human well-being, is the language normally used in the scientific community. But they want to be as inclusive as possible and also include other knowledge systems, for example, Indigenous peoples, practitioners, and others. And that's why we see also in the blue other terms. We are referring to the same thing, but sometimes in just different terms. So we were seeing how the work of these and many other organizations all throughout the world, in the north, in the south, are contributing to nature's contribution to people. And a good quality of life, which we mentioned earlier. What in particular this framework does is to put at the center stage the importance of institutions, governance, and other indirect drivers. Institutions, part of them, of course, are international human rights law, environmental law, policy instruments, as it was mentioned before, such as environmental impact assessment, policy support tools and methodologies, such legal assessment tools or legal empowerment methodologies, such as paralegals, which are people that are not necessarily lawyers, but get very important tools to actually voice the concerns, interests of their communities, and not only of their communities, but also of the interest of nature as such. And if we recall the example of Wangari Maathai, she was interested not only in today, but also in future generations, what their food needs could be. And also she started working with local rural women. But then increasingly, she worked at the international and global level, and we have many examples of other people doing the same. So here, a key issue is that biodiversity underpins healthy ecosystems, which are vital for a thriving future for people and nature. And we see that there are many frontline environmental defenders, which are critical for these nature's contributions to people, which I mentioned earlier. And we see at the same time these risks that these environmental human rights defenders are using. And as Professor John Knox, the UN Special Rapporteur on Human Rights and Environment, highlighted, some of them are risking their today for our tomorrow. And as Feliz Omido highlights, we have seen many very important advances, for example, within the context of the Convention of Biological Diversity, many of them related to indigenous communities and local communities, and a recognition of their contribution to biodiversity. But as she highlights, it's not only about indigenous communities, not only about the poor or the marginalized. It is about everyone. These rights are enshrined in many constitutions, as was highlighted earlier. And we have all responsibilities as well as rights. And often when we talk about environmental defenders, what often comes to people's minds is people protesting in the streets and voicing these very important concerns. And as we know, it's a very important part of right to association, freedom of speech. However, what is less acknowledged is sometimes this silent community effort, specifically those using law to challenge those rights that violate environmental rights. Community paralegals, for example, that their news, their efforts might not reach the national, not the international media either. But by enforcing environmental rights of communities, they are changing lives at the very local level, which is very important. So we see these advances on the recognition at the subnational level of these rights, yet we see challenges in terms of enforcement, accountability of governments and businesses. The human rights lens help us view people not only as victims, but as empowered men, women, collectives, active subjects for fostering sustainability for its planet, including its people. And we're thinking here about environmental defenders as the UN Special Rapporteur on Human Rights Defenders in his report specifically on environmental human rights defenders. Even those people who not recognize themselves as environmental defenders, but promote and protect human rights related to the environment, they are legally protected by associated legislation. And here they are not only voicing their interest of their communities, of their families, but also of others who are voiceless, namely plants, animals, and future generations. And here I would like to highlight this human face on biodiversity and human rights nexus. Some years ago, when people talked about climate, it was about climatologists, it was about only statistics, issues that were very technical and just a certain number of people could understand. We see now how, of course, they continue to be very important, all these statistics, all these natural science contributions. But they have been really brought into other arenas, such as the Paris Agreement and the daily life of people. People in the streets are talking about climate change. By highlighting this connection between climate change and human rights, there's a huge opportunity for biodiversity to be the same, that sometimes it's not obviously seen how it affects everybody's life in the short and the long term. So as many of you know, this is Berta Cáceres. She's one of the many people that has been killed for their work in environmental safeguarding. And I won't go into the statistics here. There you can, for example, see the work of Global Witness, who has highlighted that in 2017, more than almost 4 environmental human rights defenders a week were being killed. And here we also have statistics of 2010 and 2015. And we see that it is a symptom. If we see a case of an environmental defender being killed and there is impunity afterwards, is that the rule of law, the environmental rule of law, is not working properly, and also other related principles. And we see that human rights may be local in their direct manifestations. They're an outcome of multi-level complex dynamics. If we examine closely the case of Berta Cáceres, we can see that, of course, it happened in Honduras, but it's worth highlighting the duty of care that, for example, financial institutions based in other countries have in terms of due diligence to ensure that their projects are not violating human rights. But also on the other side, in terms of the proposals that are being put forward, this case also shows how beyond silos, groups of academics, social movements, etc., were voicing together the concern of access to justice. So it wasn't only the human rights movement, it was the human rights movement, the women's movement, environmental movement, and academics joining forces to highlight these issues. And we see, for example, importantly, the UN Environment Initiative that was mentioned earlier. So here also having a positive force, as we saw it launch now in the last Human Rights Council, and it had a very positive uptake by people there. So we see this high time to integrate human rights and environmental sustainability, and the advances that they have been already mentioned by some of the speakers before, such as the thematic report on biodiversity and human rights and these framework principles. In the context of the Convention of Biological Diversity, it worth also highlighting the need for mainstreaming and integration of biodiversity across relevant sectors and cross-sectorally. Human rights is cross-sectorally. And mainstreaming is a key priority for the CBD Conference of the Parties. We see human rights and sustainability cross-cutting dimensions in Agenda 2030. And a standalone goal, which is an innovation if we compare it with the Millennium Development Goals, which didn't have a specific goal like this, which specifically states the aim to promote peaceful and inclusive societies for sustainable development, provide access to justice for all, and build effective, accountable, and inclusive institutions at all levels. And here, Agenda 2030 is very explicit in terms of the linkages between human rights. And I'll read it out. The new agenda is grounded in the Universal Declaration of Human Rights, international human rights treaties. The Sustainable Development Goals seek to realize the human rights of all. They are integrated and indivisible. And if you see here at the left-hand side, they are the human rights principles as recognized in the United Nations Common Understandings of the Human Rights-Based Approach. So, as it was mentioned also earlier, substantive and procedural rights and rights of vulnerable populations being intertwined. So I know all of us are working perhaps in different topics with specific emphasis on certain sustainable development goals. But just for a moment, I could ask you to imagine in any work you were doing, if we could have a world with equality and non-discrimination, of participation and inclusion, of accountability and a rule of law. If we're able to imagine that, how can we link law to these dreams, to these aspirations of people, to make it happen in practice at all levels? And in the right-hand side, you can see that the human rights principles are embedded in Sustainable Development Goal 16. Paradoxically, while we see that many of the other Sustainable Development Goals articulate how they are related to sustainability, for Sustainable Development Goal 16, it's not explicit. Hence, we need a conceptual framework that can articulate what we see as the Agenda 2030, having these cross-cutting dimensions, both sustainability and human rights. A great basis for doing that is the framework principles mentioned earlier. Here, the next step could be to specify what are the biodiversity and ecosystem dimensions. We recently produced an ecosystems and well-being human rights framework that aims to connect Sustainable Development Goal 16, the Intergovernmental Platform for Biodiversity and Ecosystem Service conceptual framework, which I mentioned earlier, and the United Nations Common Understanding of the Human Rights-Based Approach, specifically the principles that I mentioned earlier. And how does this apply into mainstreaming biodiversity and human rights in the mining sector, to provide a concrete example? In terms of dialogue, a great opportunity arises with multi-actor dialogues, and if we're serious about recognizing different knowledge systems that can come together to think about how to address connected risks and connected solutions. And here, as it was mentioned earlier, one of the initiatives that we are very excited about is a peer-to-peer dialogue co-convened by Stockholm Resilience Centre, the International Development Law Organization, UN Environment, the United Nations Human Rights Special Procedures Office, and Natural justice. And what we will be focusing there is how do we weave this human rights law, including its principles, Sustainable Development Goal 16, specifically to the post-2020 Convention of Biological Diversity, Global Diversity Framework. We'll be also doing a strategic report, a toolkit, collaborative partnerships that aim to implement both at the national, local, and regional level. So here I could encourage you to get in contact with us and share what has worked and has not worked in terms of, for example, legal tools and strategies. And we really aim to learn from different groups and individuals on this process. We're hoping to feed these into international legal and policy processes. Of course, the Convention of Biological Diversity, technical meetings, and upcoming Conference of the Parties, as well as the Human Rights Council, Sustainable Development Goal processes, such as the High-Level Political Forum. And I could like to end by highlighting what with other partners, such as the International Development Law Organization and Natural Justice and others which I mentioned, what we want to explore and to envision is what could a standalone target, mirroring Sustainable Development Goal 16 and cross-cutting human rights dimensions, could be articulated in the post-2020 CBD Global Biodiversity Framework. Doing something like that could potentially help empower different right holders to exercise their rights to benefit from and contribute to biodiversity and healthy ecosystems. Through legal empowerment methodologies, for example, which I mentioned earlier, or biocultural community protocols. Importantly, is to enhance capacity of duty bearers. And the example of the judiciary was very illustrative of this, to respect, protect, and fulfill human rights related to biodiversity and healthy ecosystems. And for this, we need intercoordination, both of ministries and other authorities, for example, Human Rights Commission, wildlife, forest, mining authorities, conservation organizations, and funders. And also it could help us enhance the capacity of duty bearers and right holders to work together, not only to be less harmful to the environment, but to be a force, a positive force for safeguarding life support systems on which humanity depends on. And I would just like to end with a quote from Wangari Maathai. And she said that sometimes in the time of humanity, humanity as such is asked to reach a new level of consciousness, to spare fear and share hope in terms of linking peace, justice, strong institutions, and sustainability for all. And if we think about Agenda 2030, of course, leaving no one behind. Thank you.
Thank you so much, Claudia, for that fantastic presentation. And thank you, Bala, Arnold, and Alfonso for your presentations as well. So I'll be taking over the facilitation for the question and answer session. And we have a couple of questions already from our participants. So I'll go with the first question from Adan Kebede. Adan asks, what tools and strategies are developed to monitor and ensure sustainable implementation of projects and programs that respect the rights of Indigenous communities? Is there any practical experience, and would you be able to show like a case study on the topic? So tools and strategies to develop to monitor and ensure sustainable implementation of projects and programs that respect rights of Indigenous communities, and if any of the speakers want to share a particular case study. And just sharing with speakers, the questions are open to all. So if any of you want to come in at this particular point, Bala, Alfonso, Claudia. And then I will also proceed to unmute Arnold's mic. So Arnold, I will proceed as well. So colleagues, if anybody wants to respond to this first question from Adan.
Yes, I mean, I could be happy to start. So I would like to share some collaborative partnership that we have with the organization called Natural Justice, which they are developing a tool, which is a legal empowerment methodology, specifically paralegals. So what they do is with the local communities and indigenous communities, they train on how can they get evidence that will be useful, for example, for safeguarding their environment, and they're working, for example, in coastal areas in Kenya, and there's another organization called Namati that is doing the same in Southeast Asia, and they are working very closely with the county governments and showing people how can they use the law, for example, to access information, how can they participate in practice in an environmental impact assessment. And I'll be happy to share some of those sources if you want to have them. And we'll have also a presentation from another colleague from Natural Justice in the last session that I'm sure could be able to share also some of his insights. Thank you.
Thank you, Claudia. Eva, can I come here for a minute?
Yes, please.
Just as Claudia mentioned, that we will have a colleague from Natural Justice who will be joining us, making a very specific presentation, answering the question to an extent on the 19th of April. Just not an advertisement for colleagues to join on 19th, but just an information. But for example, if you take India, one of the things which we are seeing very increasingly within the space of both legal jurisprudence as well as activism in terms of environmental justice and human rights is where the local communities and people who actually are interested in environment and biodiversity conservation using a legal instrument in India, which is called the Right to Information Act, where they actually are using the elements of this particular act to seek information, to ensure that the participation happens, their voices are heard and things like that. So we are currently looking at the possibility of pulling a few case studies using this particular provision of the legal framework and addressing the issue of human rights and environment and biodiversity, which will be available fairly soon.
Thank you so much, Bala and Claudia, for your response. I would just like to encourage participants also to raise their hands if they want to pose the questions directly to the presenter. Otherwise, I have a couple of questions on the chat box. So the next one would be from Aniko Polo. And he says, with all that was said by the presenters, apart from community forest, what can we say that protected areas are respectful of human rights?
Let me quickly answer that question. I mean, to an extent, it has been an ongoing debate, and as I mentioned, that I definitely draw attention. Very specific responses to this question can be found in the Special Rapporteur's report on human rights and indigenous and local communities that was presented some time ago. But the moment you're talking of protected areas, the general tendency across the world is move people out of the forests and we protect better. So biodiversity is better conserved when there are no people around and people should be moved out. And this actually had led to a lot of tension and a lot of violation of human rights across the world. But certainly things are beginning to happen, but not at the speed with which we would like to happen. For example, if you look at the IUCN protected area categories, we never had a category called the ICCAs, the community conserved areas, before. But currently we do have a category where countries are trying to actually use this particular category to designate areas that are relevant or related to people's aspirations and rights kind of thing. But certainly in the realm of protected area management, a lot more needs to be done. And currently, in general, I'm not saying everywhere, but in general, the practice of managing protected areas is to move people out, and definitely that is causing quite a bit of an unsettled responses from communities in terms of violating their human rights and things like that. So more needs to be done, but certainly seeds are already sown.
Thank you so much. And Arnold, just to remind you that your mic has been open, so if at any point
no, I just also really, I'm Alfonso, and I really want to add to that because there's already jurisprudence as discussed. There is in the African Code of Human Rights that eviction of indigenous peoples from protected area purposes is violating a variety of rights. So there's also developing jurisprudence on that, and as Dr. Bala discussed, IUCN has different categories of protected areas, and there is an increased change and shift in how we see conservation right now also. And the importance of ecosystem approach and approaches which integrate human rights and recognize human beings as a part of the ecosystem becomes quite relevant in this aspect. In addition, I will also like to mention that there is a particular act in India which is called the Forest Rights Act, which is basically guaranteeing the rights of communities to govern and manage and protect their own territories. So in addition to a Right to Information Act, legislative and laws which support communities will also be the tools and mechanisms in which we can kind of increase indigenous people's right over their resources. Thank you.
Thank you so much, Alfonso. And Claudia, you also wanted to come in?
Yes, yeah, just wanted to share with you that in Nairobi last year, and then we went to Mount Elgon, we had a dialogue which brought very interesting insights, and it was specifically that question that we were asking. And not only that, but also which tools and methodologies exist in terms of trying to recognize, to start with, that conflicts do exist, that divergences do exist, and from there and from the convergences, such as the indigenous and community protected areas that Bala highlighted, how can we move forward? And it was very interesting to see how bringing a multi-actor dialogue could build in those insights. And for example, the Wakatane mechanism, which is exactly a non-judicial mechanism that tries to address this in a constructive way. We discussed it and realized that it is a relevant mechanism, and something like that or similar could be very fruitful to further develop. This has been a lot of work done by the First Peoples Program and IUCN and others. So recognize that yeah, there's effort being done, and as it was mentioned before, also the UN Special Rapporteurs have not only had reports done, but also special communications. For example, recently, the Sengwer people, you can look at their websites where they have issued communications on this. Thank you.
Thank you so much, Claudia. So there's a question from Anoop Kani, and I'm going to open his microphone. Anoop, can you hear us? Anoop, can you unmute your microphone? So if you right-click on your own computer, there, I can see it active. Anoop, can you try speaking?
Hello, can you hear me, Eva?
Yes, we can hear you. Hello.
Hello, Eva. Good evening. Good evening.
Please ask your question to the panelists.
Yeah, the thing is that I'd like to add a few points to what Dr. Bala and Alfonso said regarding India, because I represent an indigenous community which having traditional knowledge and traditional medicinal things. I like to say that one of our community elder was awarded one of the coveted civilian award called Padma Shri recently. So which shows how India is recognizing traditional knowledge. Secondly, at the same time, I'd also like to say that even though forest right act is there in India, which gives some responsibility and which gives some right, but it's not implemented in a very uniform manner in all states. So there is a violation of human rights there. And I'd like to say that what Bala is exactly right, because Jesus and giving us the indigenous community to know what actually human rights, our right, especially cited in the Constitution. So these sort of things happening, but even then there are some violations happening from people. Actually, we supposed to have us. So these are some ground realities which are happening in India. Thank you.
Thank you so much, Anup. Bala, I'm not sure if you could get some of his comments, Anup, because we had a little bit of a problem hearing you well.
Yeah, I mean, it's just more a kind of view that he had expressed in terms of how things are happening, but a lot more needs to be done how things are not happening, which is going to be a problem anywhere. I mean, there can't be any country or any situation where a legal framework will or can be implemented to its 100% in terms of either compliance by the stakeholders or implementation from the regulators. So certainly things need to improve, and in certain areas things are improving and progressing, but in certain areas a lot of time bit of these problems comes in terms of interpretation of the provisions of some of these legal provisions. You know, on one hand, the right to the Forest Right Act in India, the interpretation of the communities are different from the interpretation of the Forest Department, is different from the interpretation of the academicians and environmental lawyers. It's also a bit of a challenge, but certainly I agree to the point that a lot more needs to be done for effective implementation.
Thank you so much, Bala, for that. Our next question is from Luisa Pisuti. So Luisa has just two questions. The first one is a follow-up to what Alfonso said about a court deciding some strict protected areas violate human rights. So if you could just repeat that one more time briefly, Alfonso. And then her other question is the following. Well, first she wants to thank the presenters, but she's wondering, what are the tools for moving from implementation of projects to the national level? So maybe taking, you know, a step-by-step, if at all possible, summarize from some of the theory to the practice. Colleagues, would anybody like to come in at this point?
No, I was just waiting for Alfonso to come for the first question, but I'll just go for the second one in terms of how do we move for national implementation, the tools. I mean, as Claudia was elaborating and mentioning, there are certain tools that are available, there are things which are in the making. But there are 2 or 3 elements which are very, very important for making things happen on the ground. The first one is that the communities, the people should, you know, be better, be capacitated and awareness be raised on their rights and obligations, given a lot of these provisions, a lot of these legally binding obligations countries have signed up to now, number one. Number 2 is that there should be a proper dialogue that should happen between the communities and the executive, especially those who are making the policies in relation to translating some of these principles to action. So what is important for us is to ensure that the executive also understand not just the legality of human rights, but actually translating the legal provisions to something which can make those changes happen and sustain those changes at the local level. And the third one is for the judiciary, who actually should look at some of these elements, not only purely from the perspective of jurisprudence, but also considering the elements of sustainable development, the social setup, the cultural setup, the kind of implementation mechanisms that are possible, that are not possible. And that is where I think we need to bring in all these three different stakeholders, capacities, and understanding into a different level.
Thank you, colleagues. Anybody else wants to come in at this particular point? Otherwise, I will proceed to the next question from
Well,
yes.
If I can
I
also
just
add,
wanted-
when we're
Yes, please, Claudia.
yes, when we're talking about implementation at the national level, I think it has mentioned executive, judiciary, and the legislative. And while we see that the constitutional law of so many countries enshrine these laws, we are also seeing how secondary regulation in terms of, for example, the extractive sector and others sometimes is not synchronized, it's not articulated well enough with other environmental regulation. So that'll be a very concrete next step, and it links very much to the mainstreaming efforts that were highlighted by the Conference of the Parties that were needed in terms of the Convention of Biological Diversity. And for this, I would like to highlight a work that is currently being done by the International Development Law Organization, and it's a collaborative partnership also with the Sweat Bio and many other organizations such as UN Environment, Convention of Biological Diversity Secretariat are working with, which is a legal assessment tool targeting specifically the national level for legally assessing how can we better mainstream biodiversity, and one specifically on biodiversity and human rights. So there's a piloting phase now in Kenya, but we're really hoping that this can be piloted in other countries as well. So please be in touch if you are a country that could be interested in furthering that. And I think another point when we're thinking about the national level, often we think about the borders of a country. What it's increasingly being now highlighted is how states' obligations, and also what Alfonso also referred to some jurisprudence on this respect, also refers to obligations towards the rights of people in other countries. So there's a lot of work to still be done on that level, but states can actually enforce and develop further regulation to make for example, companies that have their headquarters, for example, in a certain country, to do not apply double standards, but have high human rights and biodiversity standards for also their operations abroad. Thank you.
Thank you so much, Claudia. Alfonso, just want to check that you're back. We lost you momentarily. Can you hear us again?
The African Court on Human Rights, which held that eviction of the Oggie people from the Mao forest, which is their forest, is in violation of a variety of rights. So if you refer back, I think the presentation slides will be uploaded, also available to all the participants. I've mentioned that case, and you can refer to that particular case. So it is the African Court on Human Rights.
Thank you so much, Alfonso, and we will definitely share the PowerPoint presentations with all of today's attendees. We have two questions focused on Indigenous peoples. So the first one is, how can the Indigenous peoples, without proper education and legal knowledge of land rights, protect their inherited properties from corporate legal intrusions? This was from Euberto Licayan. And then a similar question also from Alberto. How can the Indigenous peoples protect their environment and biodiversity from corporate intrusions of extractive mining rights affecting the ecosystem? So essentially protecting the rights from external interests or mining companies. Colleagues?
Yeah. Yes, I know. Probably Claudia may have more direct response, and she's going to be speaking next week. I mean, on 5th of April, specifically looking at the issue of mining sector, biodiversity and human rights as a part of a presentation. But let me quickly answer the first part of the question in terms of how do we empower, how do we ensure that there is full and informed participation of the indigenous and local communities in many of these processes. It's always been a challenge, irrespective of the country where you are in, whether you're in a developed country or a developing country. It is definitely a bit of a problem of mainstreaming. But what is also happening is that a lot of international organizations, UN agencies, civil society organizations, including, for example, natural justice, all been looking at how do we translate what is happening, what is being discussed, what is being decided in terms of empowering the communities into actionable points on the ground, and work with these local community representatives in terms of ensuring their rights are properly understood and they are heard, and visible and viable platforms are provided to them. But what is required at this point of time is just not information about what is happening outside, but to an extent, a bit of hand-holding that should happen for the indigenous and local communities as and when we move forward this particular agenda, because they definitely need a lot more of support in understanding and applying some of these decisions, some of these outcomes of negotiations that will happen in international fora into something that makes sense to them, in terms of ensuring that rights are properly protected and their voices are properly heard. So it definitely has to be the work of the national governments, but it is also definitely the work of civil society organizations, UN agencies, and others. But certainly, we have had experiences of entities coming together and supporting that kind of capacity building and awareness and hand-holding for local communities. But we need more of them to come through.
Thank you so much, Vala. Anybody else would like to add to the response?
Yes, I think Vala responded excellent on this, and I would like to highlight that when we're talking about the human rights-based approach, the human rights-based approach includes respecting human rights, that is, in terms of state obligations to refrain from intervening with the exercising of rights, for example, freedom of speech, etc. But importantly, also includes protect human rights. And by protect, legally speaking, means also that the state has the obligation to have a specific legal frameworks to regulate not only state, but other non-state actors, and including, for example, the business sector, mining industry, and others. So I think understanding that this is part of the obligations of state is important, because then there needs to be affirmative action. Affirmative action meaning that specific measures need to be in place when, for example, there's different activities being carried down or being exploration, etc., an environmental impact assessment that, for example, requires that this information needs to be translated into different languages, and there's jurisprudence of that, and what is an effective and meaningful participation. So, and I think there are also very interesting examples, and that has been not only in national courts, but also in, for example, the Inter-American Court of Human Rights, and not only in terms of extractives, but also, for example, of forest exploitation and forest diversity and proper management, where, for example, there have been witnesses, both from the communities themselves, but also when somebody was asking about specific tools, where we had the legal tool of expert witnesses, where you had, for example, anthropologists giving an expert witness, Rodolfo Stavenhagen, a prior special rapporteur on the rights of indigenous people, explaining, for example, why was it so important for that specific group to have the recognition of collective land, enabling the present and future generations of the Majagna indigenous people to exercise their rights. So, of course, there's a lot to be done. I think academia can also play a role when it comes to these expert witnesses, also from natural scientists, for example, in environmental impact assessment of the quality of water and others. So there are many challenges, but also we have many tools where we can take stock of.
Thank you so much, Claudia. And I'm not sure if Arnold is still online, but as always, Arnold, if you're still around and you can hear us, please feel free to come in at any point. Our next question is from Kelsey Alford Jones. And the question is the following. What efforts have been undertaken to harmonize jurisprudence on human rights and environment with economic frameworks such as trade, ISDS, etc., that make it difficult for states to fulfill their rights obligations?
Okay, I'll try to answer, but I'm sure Claudia will have a little more information on this. To an extent, it's work in progress. But if you're going to be looking at it from a very explicit mention of some of these dimensions, whether it is related to the regional trade agreements or bilateral trade agreements or things like that, you probably may not find it. But certainly, the regional trade agreements increasingly are being receptive to some of these issues, and we have had instances of different, including the Trans-Pacific Trade Agreement, trying to look at some of these issues and things like that. But certainly, it's just beginning to happen. It still has not reached a stage where it is more visible or it is more vociferous in terms of the negotiations and finalization. But certainly it's work in progress.
Thank you so much, Bala. I don't know if Alfonso or Claudia or Arnold want to add in anything else?
Well, I could add in terms of, for example, financing, biodiversity financing, that the CBD, the Convention of Biological Diversity, but voluntary guidelines for safeguards in biodiversity financing mechanisms. So here we're speaking, for example, of biodiversity offsets or ecological compensation. We're talking about markets for green products, including, for example, certification and others. There are 6 recognized within the categories, and there are others that have been also voiced that they could also be included here. And these guidelines explicitly refer to the need to take into account, where appropriate, international human rights treaties. It's part of the guidelines that can be used within environmental law to also make these linkages between biodiversity law and human rights. It's also worth noting the voluntary principles, the UN principles on human rights and the business, and there are some efforts being done on that respect. There's also a current negotiation within the context of the Human Rights Council of new binding treaty that could address issues concerning multinational corporations, which is, I mean, still a negotiation process. There's still not a treaty as such. But I think both within the context of the Convention of Biological Diversity, there is discussion about it, and then within the context of the Human Rights Council. And of course, there's a lot of more work to be done, but the person who asked the question might be interested in looking at the organizations that are working in these areas.
And just to reiterate, next week we have 2 presenters who will be speaking or touching on elements of this aspect. One from who has worked on business, biodiversity and trade, and the other one is from UN Global Compact.
I have, well, we have 10 more minutes of the webinar, so I'd like to just quickly share with the panelists 2 more questions, and then we'll take the webinar forward with some final comments from the panelists and Bala. But I have so the first question is from Maria Cruz Gonzalez, and it's a bit related to the topic that we were addressing earlier. So in many cases, the state prioritizes granting mining permits in indigenous lands or important ecosystems because they consider this a better development investment. If this is the case, the state does not guarantee the human rights to health ecosystems. Even an environmental impact assessment is conducted there may be conflict of interest. The state wants the multinational mining companies to invest and may overlook the clauses within environmental impact assessments that guarantee local participation or information sharing. Even though the laws are in place, they are not respected in this case. States vary in their ability and will to defend human rights, especially when it comes to trade-offs between sustainable environment and mining investments. What are your thoughts? And this will take us to our concluding thoughts. So I would also like to add Mario Cabral's question to Claudia, so you can all think of these closing questions in your closing remarks. But Claudia, how can we find out the champions of the voiceless communities to help raise consciousness of the fight for the rights in terms of environmental protection? So I would take this opportunity to ask Claudia and Alfonso maybe to respond to some of these questions and include some of your final thoughts and remarks. So Claudia, if you want to go first.
Sure. I mean, I'll start with the question of where and how do we find these champions of the ecosystems. I think we can all be these champions. I think sometimes, even when we're talking about environmental human rights defenders, sometimes it's the notion that we need necessarily another Wangari Maathai, or we need another very visible personality. Throughout my fieldwork, both in Latin America, in many places in Africa, in Asia, here in Europe, I have found so many champions, so many people that in their everyday life, they're doing enormous work that, as I mentioned earlier, perhaps won't come in the media and perhaps won't come in the CBD negotiations. But it is about each of us having a very important role wherever we are. If we're in academia, then do it from academia. If you are in the government, we have a specific role to be there. Civil society as well. So in terms of where do we find it, I think we find it in ourselves and in our community, in our different spaces where we can influence. And just to link it to the question of conflict of interest, I think, of course, there are many challenges around, but if, for example, communities have better information and there is regulation, for example, that highlights that this conflict of interest of who is doing the environmental impact assessment, and not only looking in terms of the space where the mine is being conducted in this case, but also where the ecosystem approach can help us to look both in terms of geographical scales, not only the scale where it is the development being developed, but also where the ecosystem impact can take place, and also the temporal dimension of it, of not only thinking about present, but of future generations. I think, yeah, there's a lot to be done, but I think we have a lot of laws. And yeah, I would just like to end, but with the question of how do we connect laws and policies such as Agenda 2030 with yeah, advances at different scales, because at all scales need to be interconnected. Thanks.
Okay, I'll just add a couple of points. One, if you're looking at the way communities have in recent years resorted to ensuring their rights are not violated, you can have at least more than a dozen examples of communities have successfully stopped governments, stopped corporates from encroaching upon the rights of communities, whether it's in Australia, whether it is in Amazon, whether it is in India. We've got loads of examples. What we have not done so far is to understand, is to amplify, is to better share some of these experiences, some of these examples, and some of the ways in which communities have articulated the ways in which they have succeeded in trying to stop governments from not doing walking the talk or not doing the development in the context of destroying the environment. That's number one. Number two, if you're going to take issues which are currently receiving enormous attention at the political level, attention at the levels of the UN and others, issues like wildlife crime. So certainly if you're going to be looking at the dimension of wildlife crime, which is receiving attention at the level of UN General Assembly now, whether it is from UN Environment or CITES or wherever it is, to an extent, the work that is undertaken by these agencies to stop or to reduce to illegal wildlife is directly related to the violation of the human rights of the people and communities who are living in these areas. So what we also need to do is to overcome our kind of, I won't say bias, but our kind of siloed approaches to dealing with these, saying that if it's wildlife crime issue, I'll only look at it from a trade perspective, I'll only look at it from the economic right perspective, and then I'll say that this is the kind of action that should happen. I think time has come for us to broaden our scope and kind of understanding our mandates much more broadly, whether it is CITES, whether it is Ramsar, whether it is a CBD, whether it is a WTO, all of us have something to contribute, and all of these agencies have something to contribute. So what is important for us to also articulate and to push forward is to ensure that those who are a part of these processes understand the linkages that are already available, so that you don't have to reinvent the wheel every time, and you don't have to look for a particular champion to basically push this agenda individually in each of these fora.
Thank you, Bala, so much for those thoughts. Alfonso, would you like to share any of your concluding remarks and potential responses to some of the questions from the attendees? Alfonso, can you hear us? I think we might have lost Alfonso. So Bala, you shared some of your final thoughts. Any additional concluding remarks for this webinar before we proceed to the closure?
Thank you, first of all, thank you very much, because when we have these kinds of presentations, it's more the presenters who speak, and questions are limited, but quite encouraged to see the number of questions, both the depth as well as the variety of the questions that have come in. I'd like to draw your attention, as I mentioned earlier, to two forthcoming webinars, one that specifically will focus on the issue of business, biodiversity, human rights and trade, and the next one that will focus on the issue of links to the post-2020 process, issues related to indigenous peoples and local communities, case studies, specific examples that will be presented as a part of those two webinar series as well. Couple of very quick points is that in addition to some of the activities that Claudia mentioned and also Arnold mentioned in terms of the studies, development of the toolkits and things that are available, there is a plan to organize a side event at the forthcoming subsidiary body and implementation meeting in July on this topic. And the last point is that we are also looking at converting the entire webinar series, plus adding more information, case studies and things, and offering an online certificate course on human rights, environment and biodiversity in the coming months. So last point, thank you very much for all the participants, and thanks to Eva and Victoria for your facilitation, and to the presenters, Alfonso, Arnold and Claudia, for your patience and support in seeing this webinar through until now.
Thank you so much, Bala, and all the presenters. And again, on behalf of the NBSAP Forum, I would like to thank all of the attendees of the Human Rights and the Environment webinar series. For those that are not familiar with NBSAP Forum, it is a global partnership to support the development and implementation of effective national biodiversity strategies and action plans, the NBSAPs. And it is hosted by the Secretariat of the Convention on Biological Diversity, the CBD, the United Nations Development Program, and the United Nations Environment Program. As Bala said, this is the first webinar of the Human Rights and Environment webinar series for 2018. And next week, April 5th, we will host the second webinar of the series on human rights, business, and biodiversity. So I'm sure a lot of the questions that were shared today by attendees will probably be shared next week as well. So please don't forget to register. After the webinar, the forum will send you a feedback survey that you will receive via email. Your feedback is valuable for us to improve our e-learning efforts. To conclude, I invite you all to check out the NBSAP Forum website, as I said, nbsapforum.net, to continue this conversation, and we will be posting the recording of today's webinar, presentations, and as Bala had mentioned, readings for each of the sessions on human rights and biodiversity. And I also invite you to visit our YouTube channel where you can watch all sessions provided by the NBSAP Forum, in addition to these. Finally, as I said, please stay tuned for our next webinar session. And for more information, visit the forum or follow us on Facebook and Twitter. I'm Eva Gurria from the NBSAP Forum. Hope you all enjoyed this session. Have a nice rest of your day or your evening. Goodbye, and thank you very much.